Done.
All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save the United States in this honorable court. This honorable court is now in session. Please come to order.
Good morning. We have two consolidated cases here, Jordan versus United States and Sharps versus United States. And we have two housekeeping matters that I'd like to take care of, counsel, before we proceed with the argument. First, Judge Beckwith and I wish to mention something in light of the previous motion that was filed to disqualify Chief Judge Blackburn-Rigsby, Associate Judge Thompson, and Senior Judge Fisher from hearing Mr. Jordan's appeal. That motion was based on the fact that the three named judges were members of the Joint Committee who had or have a role in administering DC Code Section 11947. Neither Judge Beckwith nor I have or previously had such involvement, nor did Senior Judge Nebaker, the third member of this panel. We had nothing to do with the decisions to extend the deadlines at issue in these or in any other pretrial detention cases. As associate judges of the Court of Appeals, Judge Beckwith and I, along with other associate judges and some other senior judges, have been apprised of steps being taken or to be taken to enable the Superior Court, as well as the Court of Appeals, to eventually resume normal operations, including holding criminal trials. These steps include plans for health screening and safe operations, and physical alterations or modifications of courtrooms and other parts of the court for the protection of employees and visitors. Judge Beckwith and I have not received information as to the projected timetable for resuming criminal or other trials, nor any information outside the briefs and records in the present appeals as to how soon appellants or other pretrial detainees are likely to be tried or otherwise be able to appear in court. Judge Beckwith and I have not received any information that causes us to think a reasonable observer might question our impartiality or otherwise provide grounds for recusal or disqualification. Thank you. With that, we can proceed to oral argument and to the second housekeeping matter I wanted to raise, which is to ask counsel for appellants how they wish to divide their time.
Yes, good morning, Your Honor. Michael Meredith Weidman I'm representing appellant Landrell Jordan and also here as amicus in support of appellant Sharps. Counsel for Mr. Sharps and I have agreed that I will take 20 minutes and that she will take 10 minutes. And I will go first.
Okay, thank you. Well, with that, let us proceed to hear from you.
Morning. May it please the court, Michael Meredith Weidman on behalf of Appellant Landrell Jordan, and I am here also on behalf of the Public Defender Service as amicus curiae in support of Appellant Gregory Sharps. I'd like to reserve 3 minutes of my time for rebuttal. DC Code 11947 does not authorize the trial judge to detain Mr. Jordan after the authority of 1322 expires, because permission to extend judicial time deadlines is not the clear affirmative grant of detention authority required by this court's case law. Because neither 1322 nor 11947 authorizes the current detention, the detention order must be reversed and the case remanded for the judge to set conditions of release under 23-1321. We know from Hazel and Best that pretrial detention authority must be clearly and affirmatively granted by statute. And this court strictly construes statutes authorizing pretrial detention to ensure that no one is detained unless the lawmaker has clearly said they should be. That is something this court has said repeatedly, most recently in Blackson. This is because detention restricts the liberty of a citizen and has constitutional implications. So there's no dispute here that 1322 on its own would not permit Mr. Jordan's current detention or that of Mr. Sharp's because he's been held more than 100 days, and emergency tolling of judicial deadlines under 11-947 is not one of the circumstances enumerated in H4 as excluded from the 100-day clock. Nor does 11-947 provide authority, because detention authority isn't a judicial time deadline. 11-947 permits the chief judge to delay, toll, or otherwise grant relief from time deadlines imposed by otherwise applicable laws or rules. But the ordinary meaning of a time deadline, as even the government acknowledges, is to do something by a certain date, to file something, to serve something, to execute something.
Detention. May I ask you a question about how to read 11-947?
Yes.
It says that it applies, quote, in the event of a natural disaster or other emergency situation. And then it gives two categories of situations. The first is requiring the closure of Superior Court. And the second is rendering it impracticable for to comply with deadlines, for all those people to comply with deadlines. My understanding is that the court is not closed to the public for some time.
I'm sorry, I lost the last thing you said.
My understanding is that the Superior Court is closed to the public and has been for some time and will continue to be for however long it's going to be. So that puts us in the first category. If we're in that first category, is it relevant whether it is impracticable to comply with deadlines, whether that language applies? We have a closed courthouse, and that would seem to trigger 11-947 in and of itself.
So the
question of whether we're dealing with deadlines or not may not apply here is the question I'm asking.
So I think that the courthouse is closed to the public, but it is not closed to business. People are still being arrested and detained. Preliminary hearings are still occurring. It's a stripped down version of court operations, but it's still very much happening. And so I think under those circumstances, there are certainly deadlines that are happening. And so I think that, this has, I think that the order invoking 11-947, I don't believe has committed to one of these two theories necessarily, but it has invoked, this is an emergency and, here we are, and it's appropriate to begin applying 11-947 to the tolling of things like filing deadlines and things like that. I think that the court does have to consider whether we're in the land of deadlines, because there is, that's the only basis for detention here, according to the government, right? There has to be some authority in the trial courts to be ordering pretrial detention for Mr. Jordan. And
okay, so if that's the way we're looking at it, the authority is in, if I understand correctly, 22-13, section 22-1322, and it authorizes it when there's probable, among other situations, when there's probable cause to support the charges, and court finds by clear and convincing evidence that the defendant would pose a danger if not detained. And it sets a deadline. It says you have to, for such a person, you must bring the person to trial within X number of days, subject to various extensions, various tolling, and so on and so forth. 11-947 says that if there's a deadline that it's impracticable to comply with, then the court can delay, toll, or otherwise grant relief from the deadline. Why doesn't that apply here? Why doesn't that specifically apply in the case of a pandemic that makes it extremely dangerous, not to say impracticable, to comply with that deadline?
I think that the interpretation of the statute that has to be informed by the court's decisions in Best and Hazel, which say that the only detention authority that the Superior Court judge has is explicitly provided by statute. There's a limited amount of detention authority applied. The deadline, or what the
government... Well, I certainly agree that there has to be a statute that authorizes it, but 11-947 seems to be that statute.
So there's two questions there. I mean, the question whether, the deadline the government points to is the obligation to do something, to try the detained person by the 100-day clock or indict them by 90 days. And I think that the reason that's not the appropriate way to look at the grant of authority to detain, which is limited, is that it's possible to try or indict the person after they're detained, right? It's not the deadlines, the things that the government has an obligation to do, are things that in truth are independent of the detention authority. And I think that that is the basis. And I think we can, you look at the word deadline, when we look at, it is a very broad term. It is not very specific, and it is not the sort of language we expect the legislature to be speaking with when it is operating in the realm of preventive detention. 1322 is the way these things usually work, right? These are very specific. There are time limits. There are no limiting principles in the statute in 11-947, indicating that that Congress was contemplating detention at all. One of the things
Can I stop a second? I guess what puzzles me is I can understand the argument that says it would be nice if 1322 had also been amended to be more specific. But I think the natural reading of 11-947 is that it is meant to be an across-the-board statute. Congress didn't feel like rewriting every statute on the books that has a deadline in it. And it didn't, it's a little more efficient to do it this way. And when it says all and any and similar words, it means all and any and what those similar words mean. And why shouldn't we interpret it that way? Yes, we normally require more specificity when we're dealing with detention. We normally require more specificity when we're dealing with a lot of things. Congress is saying there's one overriding thing here. When we have a natural disease or other emergency that makes it impractical to just continue operations as they are normally, that doesn't mean we have to open the jails and let everybody out. And it doesn't mean we have to just throw up our hands and say, we can't deal with this problem. We can't call a halt. It means that we're going to give the judge suitably restricted authority to postpone things to authority they otherwise wouldn't have. I have difficulty seeing why that shouldn't apply to pretrial detention, just as it applies to everything else. Congress thought to exclude habeas corpus. And the fact that they excluded habeas corpus, the root of habeas corpus, from which involves people who are detained, from from the scope of 11-947, would seem to lend to support to the notion that everything else that they didn't exclude is included within all. How do you respond to that? I apologize for the length.
That's all right.
A couple of minutes at the end of your argument to make up for it.
I think that the response to that is, Congress may have intended to act broadly, but it is enacting this statute against the backdrop of a jurisprudential rule saying that there has to be a very clear statement when we're talking about preventive detention. And when you look at the legislative history for this case, there's no mention of detention, right? There's no mention of the sorts of considerations about imposing limiting principles, imposing additional review, imposing some sort of safeguards to protect this very intensive intrusion on the liberty interest in a statute that has no, the only limiting principles in the statute are the determination that it's impracticable to hold trials and that it's appropriate to order these delays. Those are not the sorts of limiting principles that this court in construing detention statutes has permitted.
Do you think we need, I'm sorry, Ms. Weidman, do you think we need to have evidence from legislative history of, contemplation of detention? Is that sort of something, if it's going to be narrowly tailored and explicitly stated and all of the things that you say is the backdrop, does it need to show up in the legislative history? If not, clearly in the statute?
If it's not clearly in the statute, I think that it does need to be in the legislative history. I think a good place to look for support of that is the court's decision in Covington. where it was interpreting 1322 in the context of witness intimidation, detention based on concerns about witness intimidation. And there had been an amendment of 1322 that removed statutory language explicitly requiring an intent element. And ordinarily, when language is removed from a statute, that means there's a change in meaning intended. But the court said, we don't think that that elimination of language got rid of any requirement of a nexus between, the threats that are uttered and the belief that the person was a witness. And what Judge Schwab said in that case, in footnote 6, is it's unlikely that counsel would have enacted a major expansion of the availability of preventive detention without any debate or explicit consideration whatever. I think that is exactly the case here. That's a principle we've seen in other contexts too. The court has sort of invoked. When it's something very, very important, and especially in a case like this where we do have a clear statement rule on the books, or in the jurisprudence. If we don't have an absolutely explicit statute, and I think that the word deadline is not absolutely explicit about preventive detention. I think we do need a specific grant. When we have language like that, you do need to have something in legislative history. I think that the fact that it's not there means this is just not what Congress was thinking about. They weren't thinking about it. And so consequently, they wrote a statute that's deficient. And so I think, this is a good moment to sort of address our constitutional arguments as well, because I think that
may I ask you just one question?
Yes.
When you say the statute was deficient, here's, I think, where I'm having a slight bit of difficulty. The statute says what it says. And I think the natural interpretation is it's as broad as it looks to be. To call it deficient, one has to be able to say, not simply that, we generally require more and so on and so forth, but you've got to be able to say it is unconstitutional. And so the issue is really not so much a statutory interpretation issue, it seems to me, as whether it's unconstitutional. If it is constitutional, then the fact that it is a deficient statute in the sense that, on a subject of this importance, we'd expect them to be a little more specific. We'd expect to, I don't know that is enough. You see what I'm saying?
I do. I think we do think it's constitutionally deficient and that it violates substantive and procedural process.
With purely a statutory interpretation argument.
Yes, and as a matter,
what I'm asking you is whether the statutory interpretation argument can be said to work on its own without a conclusion that the interpretation that the government pursues is not simply undesirable, but is or poor or whatever, but is unconstitutional. That's what I'd like to get clear on.
Yeah, I think that it does work on its own. I think that, our interpretation is that this language deadline simply does not reach the question of detention and does not constitute a grant of authority. As just a matter of this term is too broad, and the sort of context of the statute, the context of this court's jurisprudence on preventive detention, the sort of statutes that are required to actually authorize detention. So we think, no, it does. This is not language that is sufficient under Best and Hazel and Blackson to authorize detention. I do think also. Right,
but you see that okay. So just to be sure I understand the argument here, I'm not going to prevent you from getting to where you want to go. The way I'm thinking is that 11-947 is indeed not a grant of authority to detain. The grant of authority to detain is in 22-13-22. 11-947 is something else. The detention statute has a deadline. It says if you're detaining somebody under this statute, you have a deadline for bringing that person to trial. 11-947 is a lifting of that deadline. And it does not, it says nothing about changing anything else in 23-13-22. You see what I'm getting at? So it seems to me that to say that 11-947 is not a grant of authority to detain because it's not specific enough and the like, doesn't really, it is really an argument that's off point because the authority to detain is in a different statute.
I think, just in sort of brief response to that, because I do want to turn to our constitutional claims, I think that analysis sort of assumes that the grant of authority in 1322 is somewhat unlimited, right? And that there's a default of detention authority that is just conferred by 1322, and it's limited by this movable deadline. But if that is a deadline that is the time to trial, if that's a deadline that can be moved, that's fine. And there's this underlying grant of authority that is going to expand as necessary. I think what this court has said in Best and Hazel, right, is that we can't
not
actually,
if necessary, if provided by statute, some other statute.
Yes, yeah, correct. If provided by statute. However, I think that there's not a dispute that 1322, that under the strict terms of 1322, without the operation of 11947, there is no detention authority here, right? That we have, Mr. Jordan has passed the time frames, the limited grant of detention authority provided by 1322 has expired. The question is whether 11947 somehow operates to allow it to come back to life. And I think that looking at detention authority as
it extended it before it expired, so
well,
it's not bringing it back to life after it's dead.
I mean, I think it seems as though, you know, I understand the court's take. I think that we differ fundamentally about the conception of the detention authority. And we think that if it does have to be affirmatively granted, moving this, the only thing that can be the deadline is its obligation to try or indict. And because that can be done at some other time, whether or not this person is detained, the detention authority is done.
So in a much simpler case than this one, suppose on the 100th day, the marshals bring the defendant down to the court in a bus, and there's a huge snowstorm, and the roof of the Superior Court caves in, and they just can't go forward. Does it for that day and maybe for a few days? Do they have to release the defendant under that situation?
I think that's.
And the chief judge says, "Well, fortunately, 11947 comes to our rescue here. We'll see you in court next week."
I think that as a practical matter, I think 1147 does not authorize detention there. I think that, as we said, it's not an affirmative grant of detention authority. So I think that what would probably just happen in those circumstances, because trial is at a known immediate date, and in those couple of days, the person is going to get all the protections of trial. I think functionally what would happen is everyone would just sort of say, sure, let's go on. It also would be under those circumstances, because it is such a limited time window and a snowstorm ends and we know it's going to end and we know we'll be able to have a trial afterwards without much delay. The government could ask for a continuance, a 20-day continuance or less, like a 4-day continuance, and it would certainly be granted. So there's no point in saying he has to be released in those couple of days, because it's not going to succeed. I think that the problem here is
could the government here have asked for 20-day continuances seriatim because of the pandemic?
No. I think that there's nothing in 1322 that is. That contemplates that these 20-day continuances can be stacked in the service of some unknown future unforeseeable date, right? Those are concrete, particularized findings about a particular case and the investigation of that particular defendant. And I think any kind of blanket, using those as a proxy for just a blanket, indeterminate tolling, I think has no support in the statute at all. I think a snowstorm is very different, right? Because it is very limited. It has a very short deadline. It affects the defendant's ability to be there too.
I understand that it's different, but from the point of view of statutory interpretation, I'm not sure it's different. Well, let's get to your constitutional argument.
Yes. Thank you.
Counsel, I have a question for you.
Yes, Judge Neberker.
Can you hear me?
Yes, I can.
All right. You've confined your argument pretty much to statutes and the Constitution.
Yes.
But I suggest to you that wars and pandemics, some loss of freedom short of death, is the cost of survival of the nation. That reality must now be recognized, I submit, since our ordered society has no choice but to adjust. For the nonce, those adjustments must be squared with the constitutional, for we know not when the pandemic will end. Thus, my view of this matter goes beyond statutes and constitution. That may sound drastic to you, but I suggest the circumstances are equally as drastic.
Thank you, Judge Nebaker. I understand absolutely the context of the very difficult circumstances and the dangers to the public that have made things so complicated for the court. I would, I think, respond by urging the court to consider Hamdi's commentary that it's in times of greatest peril where we have to be most protective and most exacting in our attention to procedural due process concerns in particular.
All right, now the relief you're seeking ultimately is release of your clients, right?
That's correct. So maybe why don't I back up and sort of launch our argument a little bit more sort of in terms of substantive due process and some of the authorities we're kind of looking at there. If this court does find that 11947 authorizes the trial court to detain Mr. Jordan as long as the emergency orders persist, then the statute violates due process because it eliminates the strictly limited duration that was a key feature of the carefully delineated scheme Salerno relied on, and it imposes no corresponding limiting principle to safeguard the enormous additional infringement on liberty.
Can I interrupt, Ms. Weidman, and say, is the focus really on the indefiniteness as opposed to the duration? And, you know, if the chief judge issued an order saying in 2 years, 2 years from the day the first order was issued, we will move forward, would that satisfy due process?
I think that, I think it's a much closer question. I think the indefiniteness is an enormous problem. I think that if the detention is 2 years, we might be in a situation where a scheme overall is still appropriate. I think that there would still be questions, though, very serious questions about whether you have to narrow the class of people that's applying to, and whether you need to kind of ramp up the procedures, right, to make sure that you are detaining people who the government is going to actually be able to, is likely to be able to prove its case against, right? Holding people for 2 years on a probable cause determination is difficult and very challenging under substantive due process. But here, the indefiniteness is a terrible problem. You know, this is not something like a snowstorm, right? Where there's a concrete end, where it's foreseeable when all of the procedural and constitutional rights of a trial are going to be available. This is a time when people who many have not been indicted. They're only being held on probable cause. They're being held based on rebuttable presumptions that no conditions can hold them, which has allowed judges to bypass the detailed consideration of factors that they might have to do to really ensure that this person needs to be detained as opposed to someone who can be released using technological advances. So yes, I mean, Salerno, when it reviewed the Federal Bail Reform Act, really relied on kind of three interlocking constraints in saying that this was an infringement on liberty that was permissible and permissibly targeted, right? One of those was the strict time limits. One of those was confinement to the most dangerous offenders. And the third was robust procedural protections, right? And so we think that once the strict durational limits are eliminated and replaced with, we don't know, we have an amorphous emergency that ebbs and flows, and it's really unknown how we're going to be able to accommodate these trials even after the courthouse can open because there is such a backlog.
Is your argument foreclosed by this court's decision in McPherson?
No, it's not. I think that McPherson, first of all, was operating in a universe where trials were happening according to schedule, and all of the procedural protections that were available through trials were.
Well, suppose we think we were operating in a universe in which trials are going to occur again. In all likelihood, they'll occur in 2021, and the defendants here, people who are pretrial detained, will be will be at the head of the list in terms of who gets tried first. Now, it may not happen until 2021, but If you were to say, look, we're operating in a universe where trials may never occur, that's hard to buy into.
I think it's not that they'll never occur. I think it's that we don't know how long it's going to be. And
not exactly.
But we know it's going to be a long time. We know it's going to be a long time. You know, we have, I think that in Mr. Jordan's case, the next status hearing is not until the end of March. You know, the predictions are, you know, I think we cited in our reply, there was a McKinsey study that said we think that it won't be until the end of the third fiscal quarter of 2021 that we begin to approximate the kind of herd immunity that allows us to sort of get back to normal operations. And that's not accommodating the huge backlog of cases that's going to exist already, right? So it's going to be a long time. It already has been a long time. It's going to be much longer. Mr. Jordan is going to have to wait in line behind all of the people who, you know, were scheduled for trial right before the pandemic hit. He was arrested in May. He was arrested after all of this began. So it's a very long time. I think McPherson also, the trial judge in that case in the order specifically referenced some of the other outside of 1325 time constraints, right? Dismissal for undue delay, I think Rule 48, and I think 23-102, I might be citing that incorrectly. So saying that, you know, after a person has been held for 9 months without indictment, then, you know, we need, the case is going to be deemed abandoned, right? There were constraints that were in the background of that case. And so there was no consideration of a situation where we just don't know when these trials are going to occur. And so I think that is a huge, huge differential in this case. I think that, again, you know, these have been, in contrast with what we see in Salerno, we have this elimination of all the time constraints. There's no recalibration of the offenses covered and no adaptation of any of the procedural safeguards. These limiting principles that I spoke about earlier of, you know, it's impracticable for trials to be held and it's appropriate to issue an order are not the kinds of constitutional guardrails that work. They're very discretionary, and they turn the statute into an arbitrary scheme that doesn't provide enough limitation on the incursions into liberty interests that are going to be happening. I think,
counsel, I have another question. Have you looked to see how the states or the federal trial courts are handling this situation?
Yes, Your Honor. So many states have operated within their speedy trial provisions to toll some time during the emergencies. The federal courts don't have a general tolling provision equivalent to 11947, but their Speedy Trial Act has an ends of justice exception to the time constraints for pretrial detention. We would submit that even that requires more than what has to happen right now, because to satisfy the ends of justice exception, there has to be an actual continuance granted by either, it can be on the motion of the judge, but there has to be an actual continuance granted. There have to be findings in the particular case that the interests of justice outweigh the
it sounds like
we have that here.
No, we do not.
It sounds like you're making a procedural due process argument rather than a substantive due process argument. On the substantive due process argument point, it seems to me that what this really amounts to is a concession that the statute is not facially in violation of substantive due process. It might be in an individual case, depending on the circumstances. But the reason I say it's sort of a concession is because you're acknowledging that with procedures that you consider appropriate, I don't mean to say Mr. Jordan, because you're acknowledging that as a facial matter, you can have duration of this. You can have an extension of the deadlines of this indefinite duration, and I do think as a facial challenge on substantive due process grounds is a very hard thing to mount here.
So I think that there is both a substantive due process problem with the statute, and I think there is also a procedural problem, which I would like to talk about in a moment. I think that on the substantive point, the procedures are relevant because if you look at Salerno, their analysis took that into account, right? The question that they were looking at in Salerno was whether this was a carefully delineated scheme, right, that limited the incursion on the liberty interest. And these three things all work together, right? The strict time limits, the robust procedural protections, and the limited category of people that it applied to.
When you say strict time limits, I really wonder how to read Salerno, but when you say strict time limits, the time limits under 23, 13, 22, and under the corresponding federal statutes are anything but strict. In truth, they are, depending on which statute we're talking about, they are subject to all sorts of tolling, all sorts of extensions, indefinite ones, when you add them all up, and hard to predict ones, wholly apart from 11-947. And a defendant who's preventively detained and who personally wants to get to trial quickly, nonetheless, under those statutes, can be detained for quite a long period of time, not what we would call a strict time limit. What there are conditions, and there are relaxations, and there are tollings, and 11-947 would seem to fit into that. And certainly, it doesn't suggest, given the lack of strictness in point of fact, in reality, it's hard to see how, for me at least, to see how the kind of extension we're talking about here is facially a substantive due process violation. That it cannot, I don't really want to use the framing of Salerno because it's a hard framing to understand, but that cannot be upheld under any circumstances.
We think the scheme is rotten. We think the entire scheme that 11-947 is imposing right now, that is permitting people to be held for protracted and undefined terms of pretrial detention, based on nothing more than the original 1322 findings, which were built for a completely different and much more limited system of detention. And these mushy determinations that it's impracticable and appropriate to issue these orders, that is a rotten scheme under Salerno. Salerno says you have to be specific and you have to be concrete and you have to impose limits. And it's true that the Federal Speedy Trial Act, and I think more so than our statute, has tolling and extensions and conditions. I think that, first of all, those were not mentioned and discussed in Salerno. What Salerno pulled from the Federal Speedy Trial Act was that initial cap, right? That default cap, if none of those conditions apply. And it has hammered that language, right? It hammered that language in Salerno, it hammered it in FOSHA, right? That is in Zadvitas. We have seen repeatedly the Supreme Court look at Salerno and say strict time limits are really important when you're talking about detention without trial. And I think that, this is not a case where we have just moved the boundary and said, oh, it's 2 years. Don't worry, you're going to get to go to trial and have these provisions on a date certain. I mean, that is not a situation we're in. This.
Well, can I just ask you about remedy when you mentioned the 2-year thing? It seems clear. I mean, correct me if I'm wrong, but that the statutory argument would lead to a remedy of release because there's no authority. But the substantive due process argument, I guess you're seeking release, but would it be possible to interpret the scheme in a way that would resolve the problem?
So I think that sort of brings us to our procedural question, and I think that if the court disagrees that the entire scheme is rotten and believes that protracted and undefined pretrial detention under 11-947 doesn't violate substantive due process facially, we think that procedural due process principles do require it to construe 11-947 to include some enhanced procedural protections, because the procedures built for 100-day detention aren't going to be enough to provide protection when the detention begins to stretch for many multiples of that initial period, perhaps.
And do you have what does that look like? Like instead of clear and convincing, it's beyond a reasonable doubt dangerousness? Or?
So the areas that seem to us to be most problematic are, first of all, we think that there's a lack of individualized consideration right now at the 100-day mark, and that past 100 days, the burden should be on the government to justify the continued hold at a hearing. In 1322 land, the government has to make a formal written application for a 20-day extension. So it's reasonable to require them to justify the continued hold once things have stretched for 100 days or more. We think that the reliance on probable cause rather than substantial probabilities, like a Jeffers finding, is a big problem. That's, substantial probability is going to be a more fitting standard where the government has now had 100 days. If it's one thing to rely on probable cause in the first flush of the case when time is very short and there's not been time to gather information, it's another thing entirely when 100 days have passed. And at that point, especially when we're looking down the barrel of, who possibly years of detention, the government needs to be able to show that it's likely to be able to prove these charges. There has to be something more than just probable cause. I think, if you just to step out of that for a moment, if you reflect back on the Edwards decision, which was this court's first review of 1322 back in 1981. In that case, it was a difficult case for the court, and that contemplated 60-day detention and required a finding of a substantial probability that the defendant actually committed the offenses. Under those circumstances, this court wrestled with the issue, and Judge Farron, in his partial dissent, had some very interesting things to say about how probable cause is a standard developed in the Fourth Amendment context, for police officers, to protect police officers when they're trying to make a judgment in the heat of the moment, right? It's not appropriate or just to rely on that finding for even 60-day detention. And I think that the force of that is felt even more when you look at the nature of detention we have now. And then finally, I think also the reliance on presumptions, right? Rebuttable presumptions that no conditions of release will adequately assure community safety is another big problem. Presumptions shortcut a rigorous examination of the specific conditions available and the likelihood of their effectiveness. Again, it's one thing to rely on presumptions early on in a case where you need to make a decision quickly.
Can I ask you a question about this?
Yes.
Let me see, how can I phrase this question properly? You're identifying respects in which the procedures are not, from your perspective at least, from other perspectives, people feel differently, but from your perspective, ideal. But these are the procedures that the legislature decided were suitable for the occasion. Now, to test them under procedural due process standard, to say, well, even so, they do not satisfy procedural due process, even though they are fully in accord with what the legislature decided was appropriate for this sort of situation. I'm not 100% sure whether you apply a Matthews v. Eldridge standard or a specially different standard for criminal procedure determinations, but it's not obvious that, to me, that merely because we're talking about prolonged, indefinite, although I quibble with that word, I think, but detentions, it's not obvious to me that as a constitutional matter, the procedures that the legislature fairly thoughtfully selected can be said to be unconstitutional. The broad standards that make us hold these procedures in general to fairly high standards perhaps don't apply when we're dealing with emergencies, when everything is up in the air and we're trying to just keep the balls, juggling without dropping any, let alone provide all the niceties of procedural fineness. I just wonder whether there's really a basis for identifying a procedural due process deficiency here. And relatedly, I wonder how much your briefs have really raised procedural due process and argued the procedural due process point.
Sorry.
Go ahead.
So as to the first point, I think the legislature has not carefully decided that these are the procedures that are sufficient to ensure liberty when we're talking about protracted and undefined detention of this sort during an emergency. With no 11947 has come in and stripped out a key constraint, a key characteristic of the statute that the legislature wrote. So I don't, and did it with no legislative debate or discussion about constitutional implications or procedure, right? So there has been no legislative determination that the procedures of 1322 are appropriate and sufficient for the kind of detention that exists now. And people are being held for an unprecedented amount of time as a blanket matter with no individualized findings at all, simply because the court has not managed it is facing a very difficult situation. There is no question about that. But keeping all the balls in the air, sort of turning to the second part of, well, keeping all the balls in the air can't mean that everyone else gets to sort of figure out how to operate best, and people who are detained before trial on a probable cause finding just have to sit in jail for who knows how long waiting for their day in court. That's a very, very serious thing. And it cannot be that these individuals fall to last in line. There are people who are being held right now on, charges like burglary too, right? There, many, many, many people are being held. Mr. Jordan, for instance, is someone who has been held, even though he's been living in the community for several years without incident. The offense on which he's being held occurred nearly 15 years ago. His intervening offenses were not violent offenses. It was, taking money, like bait money from a cop in the metro. And he did have a couple of firearms offenses, but they weren't used. There's no, because of the use of presumptions, because Judge Kravitz in this particular case, looked at the presumption of dangerousness that applies, the presumption that no conditions can provide, can ensure community safety. There's not the kind of rigorous analysis you need to go through to say, well, how about GPS? How about home confinement? I mean, how about release to a custodian? How about all of the things that we could work together? Are those really feasible in this situation to make sure that this unprecedented incursion into the liberty interest for who knows how long before he can have his day in court is tailored enough? And so, no, the legislature has not spoken to this. In terms of there's precedent in Lynch for reading these procedures into a preventive detention statute. Lynch is where the court held that the reason to believe language in 1325, which had previously been construed in DeVoe to mean probable cause, in fact, had to mean clear and convincing evidence, right? Clear and convincing evidence doesn't appear in 1325. It's an interpretation of statutory language that had been conclusively interpreted to be something else, right? So, and also in Lynch, the court held that the procedural requirements of a hearing and so forth from 1322 applied to 1325, even though 1325 doesn't list those requirements itself. So there's precedent for this court to to interpret statutes that are missing necessary procedural requirements, to add those to save their constitutionality. In our briefing, we have argued that this entire scheme is rotten, and that so we think the whole thing fails. We think no one can be legitimately held under the statute right now. Part of the problem is substantive due process, and part of the problem is that, as we have argued, the procedures built for 100-day detention under 1322 are no longer adequate. And these are some of the things that I'm discussing now that we think present particular problems. We think that it is well within this court's authority to be able to go in and say, look, this is an unprecedented incursion. This is something new and different. We have to make sure that we are doing it carefully and that we're giving adequate regard to a real liberty interest that's at stake. I mean, this is not just an organizational problem, right? These are people's lives that are on hold, waiting for an indictment in some cases, right? Waiting for these initial steps. Many of these people are going to be acquitted. Some of them won't even be prosecuted ultimately, right? So, these are the burglary 2 cases that came up to this court. The government had been opposing release, even though people had been detained for approximately a year. And it was only when the appeals came to this court that the government offers a plea deal and allows those people to be released. So this is operating in the real world in a way that is affecting very, very many people very seriously. So at minimum, we think the court needs to make this statute needs to make it more targeted and more protective of the liberty interest, so that as in Hamdi, and in this case of serious national public health problems, we don't write out these liberty concerns and these critical due process concerns that should be at the core of our thinking here.
We will give you a reasonable amount of time for rebuttal. Let us hear from Ms. Willens. I'm not sure I'm pronouncing your last name correctly. Is it Willens?
Wellitz.
Wellens. Ms. Wellens.
Good morning. May it please the court, Carrie Wellitz on behalf of the appellant Gregory Sharp. I'd like to reserve 2 minutes of my time for rebuttal. And of course, in an effort to not be redundant, I'm going to try to do that. I'd incorporate obviously all of Attorney Weidman's arguments. I think it's important as we sit here talking about statutory construction, the Constitution, regulations, codes, words, that we look at what's behind the words. Mr. Sharps was presented on October 5th, 2019 for a crime that was alleged to have occurred over 8 months earlier. As of today, he has been sitting at the DC jail for 14 months, 427 days of his life on a finding of probable cause. I believe, and I believe that my brief lays out, that this has become excessive and punitive. And Judge Glickman, you mentioned that you don't believe that there is an indefinite period of time that these people are being held, that certainly some point at the end, these people will have their day in court, they'll have their trial. I'm not making light, and I wish not to make light of a serious situation. We've all been scrambling to figure out how to obviously work, live, but this has become indefinite. Mr. Sharps does not know when he will go to trial. He has no idea when he has his scheduling hearing, which is now set for April. Mr. Sharps has had 4 status hearings that have now been continued into the new year. He has only been seen in court once this year, once in the calendar year of 2020. He will not be seen until 2021. His confinement is indefinite. He has absolutely no idea when he will be going to court. And I think it's important, especially when you look at the briefs, particularly the reply briefs, that right now the trend looks like nothing is getting better. Things are getting worse. And
Ms. Wellitz, is it?
Wellitz.
Do you feel like the vaccine on the horizon has changed your argument at all? I think maybe when the first briefs were written, that wasn't the case.
No. I mean, at what point will the vaccines be given to the jail population, right? I understand that at this point, vaccines are coming and the vaccines are starting with first responders, as they should. But I don't think that the vaccine really has any impact on the jail population. Me as a trial attorney, I'm certainly probably not the first person in line that they're going to give it to. Jurors, I mean,
well, I just mean it is being sort of presented as the beginning of the end of the pandemic, light at the end of the tunnel, trials.
It's a glimmer of hope, but I really don't think it's a light at the end of the tunnel for someone that's been incarcerated for 14 months and has no set trial date. There is no, and I know that the court is making adjustments and they're moving and they're pivoting, as they should be, to try to get things done. But the pivoting isn't happening enough when you're looking at someone whose liberties are at stake. The pivots, include putting up plexiglass and trying to figure out how to do jury trials and start jury trials in the new year. But conceivably, are we really going to start calling jurors in January for March trials when January is the biggest, flu season? And when we have so many numbers that are escalating, and the fact that as of now, yes, there might be a vaccine, but, PG County and Maryland and all of the counties in Maryland and the District of Columbia have actually gone backwards in time. We're sitting here over 9 months after we last physically went into court, and we still have no idea when jury trials will begin. And when jury trials begin, yes, they will start with detained cases, but they'll start with detained cases for individuals that had trials set in the year 2020. That is not Mr. Sharps. He did not have a trial set in 2020. So what does that mean for him? Does he mean at the end of 2021 he'll have a trial? In 2022 he'll have a trial?
Recognizing that is true, and that, or assuming is a better word, that is true, and that it is entirely regrettable and unfortunate for all the reasons that have been identified, that Mr. Sharps cannot be tried more quickly, and that there's so much uncertainty about when he will be tried. What are we to do with the fact that there's a finding amply supported, I think it can be fair to say in his case, that no condition of release, finding by clear and convincing evidence, that no condition of release would serve to protect the public.
I mean, I think that finding is incorrect, but I think that it's not enough to, it doesn't outweigh an individual's liberty interest.
One could disagree with it, but, you know, we don't normally substitute our judgment for the judgment of the trial court on matters like that. If the trial court's judgment is a reasonable and one supported by evidence.
I think that the standard that the trial judge used, even if they found clear and convincing evidence, isn't enough when you're dealing with preventative detention that has become excessive and punitive. I think that there needs to be a better and higher standard when you are bypassing the strict regulations in 1322 that require this trial to be held within 100 days. I mean, I understand all of the arguments that Your Honors made while talking about 11-947. However, I also believe that it's true that the intent of that legislation was never, ever thought out 9 months, right? When you read actually 11-947, you're looking at something that was drafted that anticipated 14-day extensions at a time.
We have a once-in-a-century emergency. The last time we had an emergency like this was over 100 years ago.
I agree.
You know, one might well say that that the seriousness of this and the unusualness of this constitutes significant justification. They did think of disease. They clearly thought that the prevalence and outbreak of a serious disease, which is the kind of thing that can last a while, justified 11-947.
I think that, oh, I'm sorry.
You know, they, you know, rightly or wrongly, they didn't think of the kind of outbreak that could last a year. Actually, 100 years ago was worse. It lasted longer. But then they didn't have all the scientific advances we have now. How does a court balance the extraordinary nature of this emergency with the concerns that you're expressing and that Ms. Weidman has expressed?
I mean, I think that you have to look at the language in Pope particularly. And I mean, they specifically, you specifically stated in Pope that because of the fact that preventative detention restricts the liberty of the citizens, it must be strictly construed. And if the lawmaker clearly does not say that those liberties should be harmed, then they can't be. So I think that when you're looking at 11-947, there is no anticipation of taking away substantive due process. There's no anticipation of a global large-scale pandemic that we see here. There was no intent for this to continue and this to be used, this authority to be used 9 months after the fact, even longer than that. And since the lawmaker clearly didn't state that this should infringe on the liberties of the citizens, those individuals must be released.
Do you think that if somebody has said to Congress, you understand that if there's a pandemic that requires the courts to be closed for a year or more, and that kills as many people as this one is killing, and that alters everybody's lives so dramatically as this, you understand that this that people who are in preventive detention are going to remain there for longer than the statute anticipates? Do you think there's any possibility Congress would have said, oh no, we don't want that?
I would hope so. Yes. I mean, I understand the challenges that we face currently. I really understand them, but it doesn't make Mr. Sharp's individual freedoms and liberties go away. He has them. He is being held on probable cause, and at this point, that is not enough. You know, I also
suppose he were held on clear and convincing evidence.
That is still not enough, I don't think. And I don't think that, you know, particularly with a trial date that is not foreseeable. Again, I think it all goes back to the fact that he has been being held indefinitely with no light at the end of the tunnel, with no trial date set. If we went into court tomorrow and there was a trial date set for 3 months out, which obviously is not going to happen, but that would be a light at the end of the tunnel. That would be definitive time periods that we're dealing with. At this point, it's indefinite, and it has become punitive. And I think at that point, the case law specifically says that it can't be used punitively, and it has become.
Well, I don't know what punitive means in this context, but suppose the judge said, well, I hear everything that Ms. Willens and Ms. Weidman are saying, and they have a point. So I'm going to release Mr. Sharps and Mr. Jordan on home detention. Now you understand you're going to have, you know, a couple of restrictions on you. You're going to wear an ankle bracelet. Your freedom of movement is going to be radically limited, because you are a clear and present danger to the public based on your past behavior and based on the evidence in this case. So we're going to require all those restrictions. Wouldn't you be making the same? And they'd be significant restrictions. We'll post an armed guard. Somebody's actually suggested this in a case now. We'll post an armed guard around your house to make sure that's what it takes to make sure that you behave and are not a threat and don't flee and all the rest. Now that's better than jail, I suppose. But would you be making? And I don't mean to make light of that. Would you be making the same argument that is a restriction on liberty too? That is not justified. It's indefinite in the sense you're using the word. I have to say I think a distinction has to be drawn, but and it wouldn't be my word of choice, I don't think. But it's protracted. It's going to be protracted. We can't tell you how long you'll be in home detention, how long you'll have to wear this burdensome ankle bracelet, how long all your movements are going to be tracked, how long, and it's going to impose certain restrictions on your behavior as a result. You'd be making the same arguments, wouldn't you?
Might I make the argument that that's unnecessary? But yes, however, it's not.
But the same substantive due process and statutory and all the rest arguments.
But it's at the very least, that's not a total deprivation of liberty. There's a very big difference putting someone in a cage for 23 hours a day and allowing them out 1 hour a day to shower, make phone calls home, and then putting them right back in a cell, as opposed to giving them the freedom to stay in their home with their family, with their.
Well, now you're raising a question about now you're raising a question about the specific conditions under which your clients may or may not be to which your clients may or may not be subjected to. But I don't know that that's the basis of the current appeal.
They are detained. That is the basis.
Yeah, I mean, it's a facial challenge on substantive due process.
Counsel?
Yes.
Counsel, I would like to address or have you address a situation whereby we might ameliorate the severity of the confinements to the indefiniteness we're not speaking about. Should the government be required to periodically report whether, with the passage of time, the proof of guilt has evaporated such that they could no longer prosecute?
I mean, that would be an interesting burden on the government. Are you saying that they would have to, during this period of time that the clients are detained, state whether, for instance, they've lost witnesses or they
precisely.
I think that's an excellent idea in general. I don't think in general for all cases, even my non-detained cases. However, I don't think that it fixes the problem.
It obviously does not. It ameliorates it somewhat.
Somewhat, and maybe that would be beneficial for some individuals. For instance, if evidence goes missing or a witness goes missing, those individuals, they couldn't go to trial and therefore they couldn't be detained. But I think that the issue is a much bigger and broader one. So it would ameliorate the conditions or the situation for a select few. I just don't think that it fixes the problem. As Attorney Weidman says, we believe that the actual legislation is bad. It doesn't anticipate and it doesn't include things that should have been included. And because it's not precisely in the statute, because the lawmakers did not anticipate this and lay it out, then we can't just substitute our own opinions and our own feelings. I mean, the case law says that, especially when dealing with preventative detention. So while that situation might help a given few, it doesn't fix the root problem. And the root problem is that 1322 is the only statutory authority to hold people. And we have well surpassed the time period, particularly for Mr. Sharps and Jordan, in holding them. So I don't think it fixes things. And I think that things have been fixed. Things have been fixed by Congress. Things have been fixed by the DC Council. There has been lawmaking going on to solve certain problems with other issues, not having to deal with detained individuals. So unless that is fixed, that I think we can't just insert our own reading of, I mean, obviously we're reading the code and we're reading the statute, but the lawmakers did not write in there and did not include anything about detained individuals in the statute. So we have to look at 1322 for guidance. But I do also want to point out very quickly, and again, I don't want to be redundant. I don't want to go over anything that Attorney Weidman has already indicated. In 1322, an extension of time that someone must be detained isn't automatic. And it actually requires the government to have the burden or take the burden up to petition for an additional 20-day extension. And it outlines, as Attorney Weidman indicated, those showings of good cause and the very specific things that could be used to show good cause. But however, obviously in the situation that we're in now, government doesn't need to file anything, because right now there's no possibility of any type of expedited trial once you have an individual that has been held for 14 months. I would urge the court to look at the actual statutory language of 11947 and 1322 in the case law, which supports the fact that these individuals must be released.
Can I ask you a question? In the days before pretrial detention, defendants would, the bail bond, the monetary bail bond situation was in effect. And it was actually rather common for judges to set fairly high bonds, and the defendants were detained in jail for 14 months, take the example you've given, or longer. And with the only real limitations being those provided by the speedy trial right under the Sixth Amendment. You might be able to get relief on an individual case, but in terms of across the board. I don't recall that lengthy periods of, and they were somewhat indeterminate, how long the person would be in jail waiting trial in those circumstances, I think. I don't recall that substantive due process arguments were made about that. Do you?
I don't remember that day, unfortunately. I have only been practicing in the status quo and only practicing under 1322.
I apologize. I was around when the transition was made.
In my understanding of the bail statutes in DC and why we changed them is because we didn't want to hold people on just detain people just because they didn't have enough money to pay a bail. And I think that consideration is obviously, I think maybe at the root of it is a due process argument, right? Is that they didn't have that ability, and their freedoms and their liberties couldn't be based on something like $50,000 or $10,000. And so I'm sorry, I don't remember that day, but I do know that Mr. Sharps deserves a trial within 100 days. I do strongly believe that 11-947 does not toll that. It is not a proceeding that is meant to be tolled. It is not a deadline that is meant to be met, that the Congress intended to toll or somehow shift. It is something that can't be told. It's something that can't be shifted. It's an undeniable freedom that he is constitutionally guaranteed and clearly and explicitly guaranteed under the statute.
All right. I'm sorry, I don't mean to cut you mid-sentence. Well, I was going to say, let us hear from the government.
Thank you.
And we'll be giving you a few minutes for rebuttal too. Counsel, you've been patiently waiting your turn.
May it please the court, Mark Hobel on behalf of the United States. The Chief Judge's emergency tolling orders during this historic, extraordinary public health emergency are clearly authorized by statute and are fully consistent with due process. Now, I'd like to start by discussing the statutory interpretation issues that appellants have raised here, and then respond to their constitutional claims. With respect to the emergency tolling statute, section 11-947, it clearly and unambiguously authorizes the Chief Judge in an emergency situation like this pandemic to toll all statutory deadlines, including those affecting criminal proceedings. That's the
Mr. Hobel, do you agree that it is not a detention statute?
Well, yes, I do agree that it's not a detention statute. It's an emergency.
But your argument is, does your argument boil down to it is as if it were added to the number 5 exception in 1322, incorporated into that detention statute for all practical purposes? It's has that stature.
Yes, it provides additional independent authority to toll these deadlines, the deadlines in 1322H1 during an emergency situation.
So when cases like Best say that 1322 and 1325 are like the sole exclusive source of detention authority, how do you reconcile cases like that with this? Is it just like this statute comes along and it's kind of incorporated, or how do you see it?
Right. So
if you admit it's not a detention statute.
Cases like Best and Hazel are clear that there needs to be statutory authority to detain. There is statutory authority to detain provided by 23-1322, and then there is statutory authority to toll the statutory deadlines in 1322H during this emergency situation that is provided by DC Code section 11-947. So the statutory authority to do this is clear, and it's clear on the face of the statute. There was some argument, I believe, from Mr. Jordan. These are not deadlines. I think they are plainly and clearly, section 1322H1 plainly and clearly includes deadlines as that term is used in section 11-947 and as a matter of ordinary usage. They all
what about the language that has the word relief in it, like other forms of relief? Is that talking about the government having the relief of not having to release or not having to make trial happen?
Yes. So it's relief that can be provided to any party that cannot comply with a deadline imposed by a statute because of the emergency, which has resulted in the constriction of court operations or court closures. So in this case, because the pandemic has caused the chief judge to have to suspend jury trials, and nobody's disputing that was an appropriate response here, That's rendered it beyond impracticable for the government to bring people to trial within the 100-day deadline. And so,
but what about the idea that the detention itself is separate from the indictment and the trials? You know, the trials can go on their own, right? It's not, you're not giving up the trial.
Right. Well, the detention, the deadline is on detention. I think that was the point that Mr. Jordan was making, that there is a specific deadline in 1322 that relates to how it's a cutoff date for the government to, the 100-day deadline is a cutoff date for the government to bring a defendant to trial. It may be extended or told for good cause, as it states in section 1322 H1, or during an emergency situation by the chief judge's tolling orders, as it states in section 11-947. The deadlines, the 100-day trial deadline, there are consequences for missing it. In this case, under 1322 H3, the trial court needs to set release conditions if the deadline is missed. So it's clearly unambiguously providing a deadline, as that term is used in section 11-947. This court in the Ferguson case, which was decided in 2009, just 2 or 3 years before Congress passed section 11-947, referred to section 1322H as including deadlines, a 100-day trial deadline. So when section 11...
But if you have to admit it's different in kind from, like, you know, I need more time to file this alibi notice, right? There's a certain logic to looking at it as something that there is statutory authority that is being provided, and that authority has statutory limits on it. You know, it just doesn't seem, you know, and Ferguson, doesn't that seem like was that even at issue in that case? And it seems like a little bit of a throwaway term. It's hard to talk about it without using words that sound like deadline, but that doesn't change the fact that it's something that requires statutory authority.
Well, the common element of these deadlines, and say the alibi notice deadline, is that they're statutory or rules-based deadlines affecting criminal proceedings, and therefore both are subject to tolling during an emergency situation by the clear terms of section 11-947. I know Your Honor, you know, said, well, it's sort of used in passing, this term deadline, in the Ferguson case, and that's just a function of the fact this is a matter of ordinary usage in terms of how we use the term deadlines. Judge Glickman, you discussed, you know, a way to understand this statute involving deadlines a couple of times with counsel for Mr. Jordan, and in discussing, I'd submit in discussing the way the statute operates, that it provides 1322 provides authority to detain. It includes deadlines on trial and indictment deadlines for detention, and if you miss those deadlines, the detention authority, the release conditions need to be set. There are consequences. That's not a strained use of the term deadline at all. That's an ordinary, everyday use of the term deadline. And so a statute that authorizes the chief judge to toll all statutory deadlines, including those affecting criminal proceedings, in an emergency situation, clearly and unambiguously applies to these specific deadlines in section 231322H, and that renders these orders lawful. That's the basis that appellants here have challenged those orders, and the clear text of the statute just defeats those arguments. You know, I think one argument that's been raised here by appellants in various forms is that, especially in their briefs, is that the section 11-947 is very broad, and it doesn't list specific statutes within its scope. It speaks to all statutory deadlines, and therefore that one could simply read out specific statutory deadlines from the scope of 11-947. And specifically, these statutory deadlines that in 231322H.
But can I ask you if 11.947 accomplishes something that our case law has said can't happen except for with certain prerequisites, like it's tightly regulated, it's narrowly focused. Is it just immune from that, or the idea that the council didn't talk about it, that's not in legislative history? Does it have to live up to those established kind of requirements?
So as a statutory matter, what's important here is that it speaks clearly to authorize the chief judge to take this action as a constitutional matter, because I think that's what your honor's getting at when you're talking about these sort of stringent time limitations that Salerno discussed. No, it doesn't, because the specific time deadlines are not constitutionally required. McPherson is very clear on this and does foreclose the facial substantive due process arguments.
Well, I think I'm talking as well about the statutory argument, because the idea is that, to create a authority to detain, it has to be clear. And we have these sources of law that do that. And just as a matter of statutory interpretation, I'm not sure how to deal with this statute that doesn't even mention detention. I didn't mean to rhyme.
Clear. It is clear, and I don't want to conflate breadth with specificity, because it is very broad, but that doesn't detract from its clarity. All statutory deadlines, including those affecting criminal proceedings, clearly includes these deadlines. I note, the Section 11.947 doesn't include any specific deadlines at all. That's not the way that Congress designed the statute. It's an emergency power, and it's applicable in emergency situations which are inherently unpredictable in scope and duration. And we have certainly seen that here in this unprecedented and extraordinary emergency. And, just this past term in the Bostock v. Comstock County case, which is cited in our brief, the Supreme Court, albeit discussing a very different statute, but had this to say about statutory interpretation that I think is very on point for the arguments appellants are making. There's no canon of donut holes. If you have a broad statute that specifies a broad rule, when Congress chooses not to include any exceptions to that broad rule in the statute, courts apply the broad rule. Here we have a broad rule. The chief judge can toll all statutory deadlines, including those affecting criminal proceedings, during an emergency situation. So again, there's no canon of donut holes that allows us to that would allow a court to just exclude specific statutes that don't fit within that broad category. That's what we have here. It is a broad plea or grant of authority to toll these deadlines.
In other words, what I hear you saying is that we often have canons of interpretation that statutes are to be interpreted narrowly or broadly or liberally to serve their purposes or what have you, depending on the statutes. But that those are canons of interpretation that don't override a statute that clearly goes against them, as it were, or that clearly disregards them, as it were. And your argument is that 11.947 is a statute that clearly does so, because although it does not speak to 1322 specifically, it speaks to all statutes, including specifically statutes in the pretrial criminal area, excluding only habeas corpus.
That's exactly.
Is that a fair summation of the point you're making?
That's exactly the argument I'm making, Judge Glickman. And your Honor raised the Section 11947 A4 habeas corpus unaffected. I think Your Honor made a very good point that the inclusion of that provision, habeas corpus, which deals with detention, demonstrates that the Congress was considering the implications that this statute was going to potentially have on pretrial detention, depending on the scope, and order, and that those whose pretrial detention was affected would have an opportunity to challenge that through habeas. And
doesn't that really?
So presumably, Mr. Jordan or Mr. Sharps could bring a habeas corpus, a petition for writ of habeas corpus, or the equivalent, perhaps, and say, I'm being detained in violation of my substantive due process rights. My liberty is being detained. And that would be could be either a facial challenge or a particularized challenge as applied to them.
Right. I mean, nothing here is depriving these appellants or those in the same position from going to court to challenge their detention, including the length of their detention on both statutory and constitutional grounds. That's precisely what is happening in this case. And not only in the trial court, but also a right to take an appeal and argue their case in this court. I'm sorry, can I interrupt
about the habeas corpus thing? I was wondering whether that doesn't cut the other way, because if the inclusion of it just seems to suggest to me that they weren't thinking about detention, preventive detention in a circumstance like this, because it's so clear that they need to be clear about that they wouldn't omit mention of it.
Well, in the context of the statute, no, it doesn't undermine our argument. The habeas corpus is executive, the right to judicial review of executive detention, whether it's lawful, and that wouldn't be necessary, or it wouldn't be necessary to include a provision like that if DC Code 11947 had nothing to do with pretrial detention, was completely divorced from any concerns about pretrial detention. So I think it's a fair indication that far from it certainly undermines the point that appellants are trying to make, that Congress didn't even consider the implications on detention that a broad emergency power like this could have. Absolutely.
Do you agree that you seem to be making this argument, but I'm not sure what your position is. Do you need to say that it's completely clear? Like if it's not clear, do we then err on the side of liberty?
No, I think if the court were to find that this statute was ambiguous with respect to whether Section 1322 H contains deadlines, as that term is used in Section 11947, the touchstone really is the intent of Congress and what Congress was trying to achieve by giving these broad emergency powers to the chief judge to be used in emergency situations, which Congress could not really foresee what situations would occur. And so it would be, frankly, a little bit absurd and would absolutely cut against the appellant's reading here to suggest that Congress would give this broad power and it would be limited to the sort of to tolling or filing deadlines, or Your Honor said alibi demands, more deadlines that wouldn't have the profound consequences that missing these deadlines have, because the consequences.
I'm sorry. So your point that the clarity of what they're saying, if the fact that the 1322 was amended twice since 11947 was passed, is it your position that the legislature didn't need to clarify this because it's already so clear?
Yes, the council didn't need to amend to take the sort of belt and suspenders approach and put it in section 1322 because the authority is already contained in section 11947. In other words, this court should not read anything. There's really no significance to the fact that other aspects of 1322 were amended after Congress passed 11947. And those amendments have, in fact, didn't even have anything to do with 1322H. It's really of no consequence to this case.
Well, I guess one of the questions is how aware is the council or the Congress of these kind of debates and disputes? You know, like is there any evidentiary value to the fact that the council didn't or Congress didn't, modify 11947 to be clearer about its application to 1322, like this week, or last week?
No, I think Congress spoke clearly in giving a broad grant of authority to the chief judge, and I don't think there's. I think we interpret the clear text of the statute. I mean, it certainly doesn't. It certainly doesn't undermine our argument. I guess I'd say that the chief judge is exercising this power since March, and that Congress hasn't sought to pull the brakes on that. It certainly doesn't undermine our argument, but I don't think we're relying on that. I think we're relying on the clear text of the statute and its broad purposes as an emergency statute. The consequences of the reading of the sort of the consequences of the situation. I think the appellants were pretty candid about this. The consequences of a situation in which there is a major disaster that shuts down the court, and there is a dangerous defendant who's hit his 100-day mark and about to the deadline's passed and about to go to trial, and that trial can't continue, and the government's not in a position because of the emergency to move for a 20-day good cause extension. Those would be pretty devastating consequences. That would be release of a dangerous defendant found by clear and convincing evidence to be dangerous into the community because the government missed a statutory deadline that nobody would argue the government was in a position to comply with given the emergency. So just to circle back and complete sort of an answer to your previous question, Judge Beckwith, the consequences of being unable to meet these deadlines are profound. In an emergency situation, this is exactly the sort of statute, the statutory deadline that you'd expect this type of broad emergency power to cover. Now, I want to just briefly address this question of whether this is indefinite detention. This is not indefinite detention for a couple of reasons. As first, tolling statutory deadlines in the pretrial detention statute during an emergency situation, that's not indefinite detention. Section 1325A doesn't contain any specific trial deadlines, doesn't contain any specific time deadlines on detention. We wouldn't consider 1325A to be indefinite detention. The constitutionality of 1325A was upheld in McPherson. With respect to the timeline here and the practical situation we confront here, I think Your Honor, Judge Beckwith alluded to the vaccines, that there is cause to believe that the situation with respect to the court operations is hopefully going to change dramatically within the next year. I think one of your honors discussed light at the end of the tunnel. There is real progress. And not only is there progress on the medical front, there is a substantial progress in Superior Court itself. The Superior Court has completed its first detained non-jury trial on December 1st. That's the first trial since the start of the pandemic that's been completed. My understanding is the current plan in Superior Court is to resume jury trials in March of 2021, in early 2021. The court has invested a substantial amount of time, money, and effort to convert the court to a manner in which we can safely hold jury trials again. So I think it's the situation we're facing now is not indefinite detention as sort of in a legal sense or in a practical sense at all.
But your opponents make the argument, 1325 is different. It's designed for a different group of people. And also, you mentioned a year, and maybe when you look at the speedy trial cases and you look at some of the other cases, you will find authority for saying that's not unconstitutional under certain situations. But as Ms. Willets said, her client's been, the fact that they're in jail beyond what the statute suggested they should be or would be is kind of the problem. I mean, one of the problems.
Well, as a statutory matter, there's no statutory violation here because the chief judge was clearly authorized by Section 11947 to toll these deadlines in an emergency. So the 100-day trial deadlines in Section 1322 have not expired. I think Your Honor is raising constitutional issues, and so maybe I can pivot now to discuss the constitutional and the due process questions that appellants have raised here. I think with respect to the facial constitutional challenge to suspending or tolling the specific deadlines in Section 1322, that challenge is foreclosed by McPherson. McPherson held very clearly, due process does not require specific time limits in a pretrial detention statute. That's consistent clearly with 1325, which McPherson dealt with. It's also consistent with 231322, which does not contain an upper bound on detention. The statute's very clear that the government can seek multiple 20-day extensions for good cause, and that there's no limit. And I think pretty clearly the government could, under these circumstances where the chief judge has suspended jury trials for because of the pandemic, and nobody's disputing that's warranted here. We could seek good cause extensions in all of these cases. We'd have to go, there are numerous cases, probably hundreds of these cases. We'd have to go every 20 days to see in each one of these cases to seek that extension. It would be enormously burdensome on the Superior Court and on this court to
I think that that counsel's internet connection with us has frozen for a moment. I'm referring to Mr. Hobel. Are other people experiencing that same?
Yes, same thing.
We'll catch our breath and pause while we wait for this to.
Hopefully he'll be able to go out and come back in.
Maybe this is unnecessary, but I'll ask our courtroom clerk if he can be of assistance too. Your mood is on.
Mr. Dickerson.
Mr. Dixon, your mood is on. Your mute is on.
Mr. Hobel, he went back off. I will admit him back in, Your Honors. Thank you.
Thank you.
I'm sorry. I think I was just kicked off. So
you were frozen and kicked off for a while.
I'm so sorry about that.
You were, when we last heard you, if this is of any help to you, when we last heard you, you were saying that the government could seek good cause extensions in literally hundreds of cases every 20 days. This would be burdensome for the Superior Court. And then I believe that's where we lost you.
That's right. That I realized that Mr. Jordan's counsel disagreed with this, but there is no upper limit on the number of extensions that the government could seek, and we could do that in this situation. I think the good cause would be quite clear for why extensions would be warranted, but it would be extremely burdensome to do that sort of seriatim in all of these cases during this pandemic. But there's no specific time limit there. And with respect to the Federal Bail Reform Act, the Federal Speedy Trial Act authorizes ends of justice exceptions, really for substantively open-ended reasons, including it's well recognized that this can be done in an emergency situation. In fact, that is precisely what is happening in federal district court. The situation in federal district court here in DC is essentially, for all intents and purposes, the same as it is in Superior Court. There have been no trials in federal district court this year. The speedy trial clock has been extended and told in all cases as a blanket order by the chief judge, and that's till January, till roughly the same time frame as the emergency tolling issues at order here. So,
how does the statutory justification for that tolling in federal court compare with 11947?
I think it's, if anything, the 11947 is a little bit narrower in that it speaks specifically to emergency situations, while as I think it's 18 USC 3161 H7, the ends of justice provision, speaks to just when it's in the interest of justice to extend to exclude time under the Speedy Trial Act. So it's quite, I think the Supreme Court has said it's substantively open-ended, and it's certainly been used in emergencies and is being used currently in this emergency.
Now there we have a statute that contains the tolling authority, but it's a statute that is specifically directed to criminal trials. Does it speak, and then it becomes applicable? It doesn't change detention status of pretrial detainees by virtue of a provision in the federal detention statute. Is that right?
Maybe I'm not sure I'm understanding.
I'm trying to decide exactly how parallel or not parallel to our statutory situation, the federal statutory situation is.
I think it's reasonably parallel, Your Honor. It's pretrial detention is the pretrial detention. Excuse me. The pretrial deadlines that are applicable to pretrial detention are being extended by virtue of a separate statute, and they're being extended for emergency for purposes of dealing with the current emergency. So I think it's very parallel, Your Honor.
And to follow up on a question Judge Nebaker asked earlier, are you able to tell us how other jurisdictions are handling similar situations?
I think it's a universal problem, and I've discussed the federal district court here, which faces the same local conditions, and it's using the chief judge of the federal district court is tolling these Speedy Trial Act clocks during the emergency in pretty similar timeframes to what the chief judge is doing here, and the Chief Judge Howell is doing that as a blanket matter in all cases, similar to how Section 11947 is being used here by the chief judge. With respect to, I think that's really relatively common based on the cases I've seen in other federal district courts, depending on local conditions. With respect to other states, we've cited to a couple of cases in our briefs, State v. Lebrecht from Vermont and Commonwealth v. Logie from Massachusetts, that describe the Supreme Courts in those states exercising emergency authority to toll statutory or rules-based deadlines during the pandemic that have the effect of tolling pretrial detention deadlines. So we've cited those cases in our briefs, and certainly those describe how it's unfolding in those states. And I think it's a universal problem, and many other states are grappling with this problem and using the authorities they have to resolve the common problem that it can be very hazardous to the health of vulnerable members of the community to try to bring back jury trials. And again, I don't think anybody in this case has questioned that, the reasonableness of that determination by the chief judge. I think it's beyond question. I do want to address the specific constitutional argument, the as-applied challenge that Mr. Sharps has brought to the length of his detention. In his brief, Mr. Sharps had agreed with the government as to the proper test for assessing whether the length of detention violates due process. It has to do with the length of detention, the reasons for prolonging the detention, and the strength of the evidence. And in this case, Mr. Sharp's detention is it's lasted for 14 months. Courts have frequently upheld periods of pretrial detention that were much longer, and we've cited numerous cases to that effect. Even if, as in Mr. Sharp's brief, as potentially anticipated, were not to occur until fall of 2021, and I think that's that's certainly within the realm of possibility, given the progress here. That would be approximately 24 months of pretrial detention, which is a long time, but it's not beyond what courts have upheld, especially when given that the reasons for the delay are clear. It's the pandemic. It's not something that this is not the government prolonging detention in any way, shape, or form. And the strength of the evidence against Mr. Sharps is just it's overwhelming. Mr. Jordan has not brought an as-applied challenge to the length of his detention, which is about half that of Mr. Sharps. Turning finally to the procedural due process arguments that Mr. Jordan.
Excuse me one second. There's one other, before we get to the procedural due process arguments. Putting aside McPherson, appellants argue that Salerno made it sufficiently clear that strict time limits are one of the three requirements, three legs of the stool, for pretrial detention of a defendant, consistent with substantive due process. They've also argued that as an across-the-board matter, a finding of only probable cause that the defendant committed the charged offense might be sufficient for 100 days or for a time-limited detention, but cannot be cannot, as a matter of substantive due process, justify can't say indefinite, but an open-ended, protracted, and uncertain period of detention. So that's two related, but two arguments that they're making. How do you address that Salerno argument and that probable cause argument?
Right, and in Salerno, one thing to point out is that Salerno himself had been detained pending trial for 14 months, which is the exact same amount of time that Mr. Sharps has been detained, and twice as much as Mr. Jordan. The stringent time limitations of the Speedy Trial Act referred to in Salerno are subject to the ends of justice extensions and tolling that we've been discussing. That's extremely commonplace, and the authority to do so in an emergency is well recognized and is completely consistent with that statutory provision. So it doesn't, that's number one. I'd say number two, after Salerno, this court decided the McPherson case, which again does squarely foreclose the claim they're making that there need to be some sort of specific time deadlines.
Appellants do have an argument about McPherson. Now, of course, it could also apply. This is the sort of argument that can be applied to everybody's position here, including their own. But their argument is that if you read McPherson in context, contextually, it envisions a world in which things are operating in their normal course. So that while the statute 1325 is open-ended when it comes to time, it envision a more definite time in which the trial will be held. I'm probably not stating their position as well as they've stated it, but I think I've done my best to do so. And that's what I took away.
I think, if anything, that cuts against their due process argument. Due process is flexible, including clearly in an emergency situation like this one, where it's just not, it's a matter of community health and safety that the chief judge has determined that trial should be suspended. So I think pointing to prior due process holdings of this court and saying they somehow apply with less force or don't apply during an emergency is both counterintuitive and also, as we pointed out in our reply brief, that could go for none of the relevant precedents that were decided in an emergency like this one, or specifically contemplated an emergency like this one, but that doesn't make them any less of a precedent. It's interpreting it's applying the due process clause to these pretrial detention statutes, and I think the courts are generally careful to apply constitutional scrutiny in a matter that's sensitive to the various situations that may arise in the future. So I think McPherson was careful, and it was clear, and it clearly forecloses these arguments. With respect to the procedural point on the probable cause that appellants have raised here, I think the en banc decision in Lynch really forecloses the argument that they're entitled to greater process to establish dangerousness here. And just to note too, that this isn't detention based on a probable cause. This is detention based on a finding of clear and convincing evidence of danger to the community, which is substantial in both of these cases. Found 4 times, I think, in the case of Mr. Sharps by 2 different trial courts, with a full panoply of procedural protections that have not been suspended during this emergency. Lynch Lynch essentially found that the same procedural protections of probable cause of offense was committed, clear and convincing evidence of dangerousness after a hearing, that those are procedurally sufficient for detention under 1325, which contains no specific time deadlines. So by extension, in a case like this one, where there's deadlines, but they've been told during an emergency situation, the same process is constitutionally sufficient here. It's the process that the legislature, Congress, and the council have enacted as a matter of policy, and it meets constitutional procedural due process.
What is your? I know you made the argument that the Matthews versus Eldridge balancing test did not apply because of what the Supreme Court said in the case called Medina. And I think amicus or Mr. Jordan's counsel or both responded to that, saying that's not correct because in effect DC is not a state. Have you? I'm not. What do you have a rejoinder to that?
Yes, and we cited the Kincaid v. District of Columbia case in our reply brief, in which the DC Circuit applied Medina to a DC code provision. So we believe Medina applies, and because the appellants haven't established that there's some fundamental they're being deprived of some fundamental procedural protection here that they would lose under Medina. But they lose under Matthews too. They're not entitled to additional process here. And again, I think the Lynch case makes clear that in a statute without specific time deadlines, the procedural protections they've received to establish the government has had to go through to establish their dangerousness by clear and convincing evidence. Those procedures have been followed. So we believe, following from Lynch, the procedural protections here under Matthews are sufficient. And that is especially true in an emergency situation in which the courts are already overburdened and have gone to extraordinary and considerable lengths to bring back as many operations as possible, as quickly as possible, so litigants are able to get their cases heard, and to, under a Matthews analysis, to pile on additional procedural requirements that the council hasn't, effectively rewrite the statutes here, that is simply not it's not required, and we by procedural due process. I know my and one additional point I do want to make on procedural due process, because I know my time is running out here. The Mr. Jordan, who principally raises the procedural due process claim, has argued that he's entitled to, and he and all other similarly situated pretrial detainees are entitled to additional process. And I think Mr. Jordan's counsel made the argument that there hasn't been, I guess, challenging the evidence of his detention in this case. But I think it's ironic, given the fact that Mr. Jordan has not actually appealed. He had a right to an appeal of that determination by the finding of clear and convincing evidence that he's dangerous, and he hasn't appealed that. He hasn't squarely challenged that. He's brought broad facial challenges without trying to raise the specific, appealing the specific detention finding in his case. So I think it's especially ironic that he hasn't even utilized all of the procedural protections that already are in place to prevent erroneous and unnecessary detentions. But just to conclude, I know my time has expired. I think Mr. Jordan's counsel called the situation we have here rotten. It's clear that Mr. Sharp's counsel, Mr. Jordan are frustrated by this situation. I don't think anybody is happy about this current situation. It's very challenging. But what are the alternatives here for the judge's Superior Court? One, bring jury trials on a normal basis when everybody agrees that would be unsafe, unwise, put vulnerable members of the community at extraordinary risk during this pandemic. Two, release numerous dangerous defendants who've been found by clear and convincing evidence to pose a danger to the community because the government has not complied with a statutory deadline that nobody is arguing the government could comply with under these circumstances. Or three, burden the already overburdened courts with good cause hearings every 20 days in all of these cases with appeal rights to this court, which would just be incredibly burdensome. Instead, the chief judge reasonably exercised clear statutory authority to toll these statutory deadlines during this emergency situation, did not offend substantive procedural due process in doing so. And so we would ask that this court affirm the denial of the bond review motions for these appellants.
Counsel, before you sit down, I sprang the idea of ameliorating this situation on counsel for, I believe it's Sharp. Do you require time to respond to whether, one, it would be wise, or two, possible for the government to periodically report whether it, by the passage of time, proof of guilt it possesses has evaporated or reached a point in which you would not want to pursue the prosecution?
Well, I think two points here, Judge Nebaker. First, that's not constitutionally required as a matter of due process. With respect to the wisdom of that policy decision, you know, the council hasn't made that determination. If the council, you know, it's within the policy, you know, that's a policy decision that the council could undertake, but it hasn't. In terms of what the information we're providing, I want to be clear. I mean, our general discovery obligations are not suspended here. Our Brady obligations are not suspended here. So, you know, if there's a situation where, you know, we're not, you know, we're disclosing, we're complying with our Brady obligations, and I think we're not seeking. I think it's important. We're in cases like these, we are seeking and defending detention of defendants who are demonstrated by clear and convincing evidence to be a danger to the community. I think that evidence is absolutely overwhelming, especially in Mr. Sharp's case, but Mr. Jordan's too. And you know, Mr. Jordan hasn't challenged that determination. But I think that when you look at these cases, you know, I don't think that should give the court pause in any way, shape, or form that the government is not being judicious about seeking holds in circumstances where detention is becoming somewhat prolonged because of the circumstances of the pandemic. But you know, and just as a final note, if defendants that are seeking to challenge the underlying detention decision or the length of detention or both can file bond review motions, which has been the case here, and receive a full hearing from the court, from the trial court, and from this court to challenge especially the length of their detention and whether that's become excessively prolonged and whether that violates statutes. That's happened here. We believe those challenges are without merit, but those procedures are absolutely in place to protect these rights. So for all those reasons, we'd ask the court to affirm the denial of these bond review motions. Thank you.
Counsel, thank you. Ms. Weidman, it's your turn for a little rebuttal.
Thank you. I'd like to respond just to the constitutional arguments first and then briefly touch on one aspect of the statutory argument. First, as to McPherson, I think that yes, it's operating in a completely different world. And I think that the backdrop of normally functioning criminal jury trials cannot be underestimated. McPherson explicitly references Rule 48 and 23-102 as time limits. And I think that if you look at it in this light, right, if a defendant in a 1325 case filed a motion to dismiss for undue delay under Rule 48, and the government said they can't say when they'll be prepared for trial, but there's a light at the end of the tunnel and they hope that maybe in a year or so the situation will be different. No judge in Superior Court at the time McPherson was decided would have denied that motion, right? Because it's not concrete. It's basically the government saying, just trust us. That's not the kind of showing that's required. Now, under the current situation, if a defendant were to file a Rule 48 undue delay motion and the Superior Court judge is going to say, time deadlines are told, I don't need to address the merits of this case. These are two completely different situations.
What does undue delay mean? What does undo mean?
Well, I think that undue delay is, I think there's a 9-month presumption under Rule 48. Which conveniently
but I mean undo. It just struck me that one might say in response to that, the delay here is not undue. It's caused by circumstances beyond our control, etc.
I think though that the situation
but I'm not familiar with that rule. So
okay. So I think the situation is that we have to understand McPherson within the world it emerged from. And that world is entirely different from the situation we have now. And we cannot look at McPherson as saying, as authorizing, as a due process matter, any amount of detention, no matter what, no matter how undefined, no matter how protracted, no matter what the other circumstances or procedures are. I think that is simply an absolutely foundational difference. And so I think that McPherson is off the table. We're in a completely different world given the circumstances. And I think that has to inform the court's due process analysis. I think that as to procedural due process, you know, the government is saying like this is not just there's, you know, clear and convincing evidence of dangerousness. They try to gloss over the probable cause finding. I want to point out the probable cause finding is probable cause that the defendant committed the offense. However dangerous you find a person, you can't hold them if they're not charged with something. And if the government can't prove by more than probable cause that the person committed the offense, that means that they haven't even shown that it's more likely than not that they're going to be able to prove their case at that time. We need a substantial, at least a substantial probability finding to ensure that they're going to be able to meet their burden. 100 days into this, if you're going to hold someone and impose these additional infringements upon their liberties, serious ongoing ones, there has to be an accommodation of that.
I understand that one can make that argument as a matter of policy, but I'm not sure I understand what you predicated on in terms of saying that it's a requirement. Probable cause, as you know, is generally sufficient for holding a defendant. It's a sufficiency, it's all that's required to issue the indictment, and so on and so forth. Lynch seems to be satisfied with it. Where do you find, as a constitutional matter, a stricter standard than probable cause?
I think that as a constitutional matter, what we see is Salerno. And what we see is when the legislature is legislating for a limited amount of time, maybe you can have a lower standard. But when the time has passed, it is imperative that there be strict requirements to ensure that these are the people who really need to be locked up for this outrageous amount of time. And I think that that is not something that is there. I think that this is unquestionably a greater incursion on liberty interests than 1322 authorizes on its own. I think that those procedures are going to be insufficient.
Counsel, in one of these cases, do we not have off record a videotape of the actual commission of the offense to expand on the probable cause minimum to hold?
I'm amicus in that case. I'm not here to comment on the facts of that particular case. But so in individual cases, assuming the court has, assuming the court disagrees with our statutory and substantive due process challenges to the statute as a whole, in some cases the government will be able to satisfy a higher showing. In some cases it will not. And I think that's critical. I think the other thing that's very, very important is that the presumptions that are being applied here are informing judges' decisions and limiting their thorough consideration of alternative circumstances. So there are clear and convincing evidence findings that no conditions of release can ensure safety are not as rigorous as they need to be under the circumstances. The statute requires clear and convincing evidence. Yes.
Thank you.
Thank you. So, and I want to say too, I mean, the government, Matthews clearly applies. Kincaid is not binding on this court. And in any case, that was a federal court reviewing a DC statute. One way or another, this is a DC court reviewing a DC statute. And I think Medina, if read in context, is entirely about federal courts reviewing state court procedures. So I think we're clearly in Matthews land. It doesn't matter which standard you're applying here, because I think that the sense is as the incursions on liberty increase, so do the procedural protections need to. And we have here very, very clear things that are problems that could be fixed by this court to make this somewhat more tailored, to make sure that it is restricting the liberty of the fewest people possible under the circumstances. We are certainly challenging Mr. Jordan's detention. We have said so in our briefing. As much as the government would like to say that we are not, we certainly are. Judge Kravitz rested on the presumption in his order. We're saying that as a matter of procedural due process, we should have a hearing where the government has to prove by clear and convincing evidence no conditions of release are going to hold him without the benefit of a presumption. No one can be held under these statutes, but certainly Mr. Jordan also should not be able to be. And this court is in a position to decide that. We see that in Lynch.
Forgive me, I've forgotten the exact language of the statute and don't have time to get it here. But I understand, I thought I remembered that the presumptions are rebuttable and that Mr. Jordan was entitled to a hearing at which you could seek to rebut them. You're asking for something a bit more than that? I want to be sure.
So two things. I think that there needs to be some, in terms of a hearing, I think there needs to be some further inquiry after we hit the 100-day mark. I think that the initial detention hearing is not sufficient to sort of authorize limitless, as long as it needs to go and put the burden on the defense.
What would be the issue with that further hearing?
I think that the government would need to be able to show that there's a continued need to detain the individual. And I think that's
what I don't understand. I mean, the continued need is A, probable cause, which has not presumptively evaporated, and B, the whatever the evidence and presumptions were that existed at the outset to satisfy the judge that pretrial detention, to satisfy the judge that there was clear and convincing evidence that pretrial detention was required, what would be different? And I mean, just as you had a hearing opportunity at that first stage, the presumptions are not irrational; they're just rebuttable. They just say that when certain facts are established, they give rise to clear and convincing evidence of dangerous, unless there's something else you have to say. In effect, what more do you think is required as a matter of procedural due process?
As a matter of procedural due process, so I think that what was appropriate before this became protracted and before it reached 100 days, right? I think is going to be different now. I think that the problem with the presumptions is that they don't ever disappear completely. Yes, they're rebuttable, but it's in there with like a thumb on the scale for the conclusion that no conditions can ensure safety. And I think that
that's okay if they're reasonable presumptions. I mean, they're factual, they're presumptions based on certain facts. This man did the following things in the past. Well, that's pretty relevant.
I think that what is happening is, as a practical matter, judges are not being methodical and actually considering individual conditions of release that might be possible and making a finding as to why those particular, for instance, in this case, why is home detention and GPS not going to be sufficient to ensure safety in Mr. Jordan's case when he has been living?
Was that issue raised in Mr. Jordan's case?
It was certainly raised below. I think
that's what I meant.
Yeah.
And what did the judge say about that?
I'm sorry. I don't know if there was an objection after the findings were made. I don't think that there was, but I think that the argument was certainly made that these are not sufficient. I'm sorry. I think that the argument was made that it was safe to release him and that he had been in the community, et cetera, et cetera. And so I think that what needs to happen as a matter of procedural process is when we are going to hold people this long. I do, for all the reasons we discussed, I think that probable cause finding is no longer sufficient at that point. I think that if detention is going to continue, the probable cause finding is too weak to guarantee that against erroneous detentions. You're going to have people who are locked up for a very, very long time who are going to be acquitted, who may not even be indicted, who may not be tried. That is a huge problem. I think that the government is saying it would be too burdensome to come in every 20 days asking for an extension. They haven't explained why they wouldn't be able to come in, say, at 100 days and justify the need for continued detention. No presumptions.
How do you respond to the argument that the defendant can file a motion if the government fails to do so?
Because I think
another hearing.
The defendant certainly could. I think that it needs to be on the government's burden at this point, because I think that the presumption should be against it. I think that there should be a default that this detention should not continue unless the government can show that it needs to continue this long, that this really is a person whose offense and history make him so dangerous that he can't be out. I think that those are things that are not being considered. I think that we're having a lot of people who are locked up in these cases as a blanket matter. And I think that...
I mean, one problem is I don't know that. The record doesn't establish that. What the record tells me is that you've made facial challenges rather than individual specific challenges. I fully recognize that in an individual case, the challenges might be meritorious for one reason or another. But I don't know that that's what's really before us.
I think that what is before the court is the constitutionality on procedural and substantive grounds of the current detention scheme. And I think that what has happened is we have a detention scheme that is not what is contemplated by 1322. It has changed dramatically. And as a result, this court, as it did in Lynch, should interpret 11947, the ability to toll the time period with a corresponding other side of the coin, ramping up of procedural challenges to ascertain that we are not holding too many people in prison pending their unforeseeable trial date. I think that that is the crux of it. So, you know, I think that the government says it's too burdensome, It's not. I mean, there are filings that are happening. There's litigation that is happening. They can justify things if they need to justify things. And the burden on the individuals who are being detained is enormous, right? These are people who are away from their families and their jobs and their lives, awaiting their day in court. They're going to be locked up likely for over a year. In Mr. Sharp's case, it already has been over a year, likely two. And I think that this court should the opportunity to clarify this issue on a systemic basis, because it is happening over and over and over again in different cases. And it is inefficient and unfair to put the burden on these incarcerated defendants to correct it on a case-by-case basis, when in fact it is a statutory scheme that is being used in a novel way that triggers these constitutional implications. And
you're now making a class action.
Well, I mean, I think that there are certain class-wide implications of this, I think, but, and just if I could make one final statutory point, I don't want to delay the court any further, but I mean, the government is citing Bostock for the idea that using broad language just means you have a broad sweep. And I would like to point out that the counterpoint to that is Covington, which is, Bostock was a case about extending civil rights protections to more people because they fell within the broad language. This is exactly the opposite side of the coin. This is a case that is depriving people of liberty to a much greater degree than the statute as originally written did. And what Covington says is when you have a constitutional liberty interest that's being infringed, you've got to be clear. And in fact, we're going to note when the legislative history is silent about it, right? There should be jumping up and down about this and true policy discussions about how to write a protective statute. And the absence of that is a red flag that this was not something that the legislature intended and therefore did not authorize this detention. Thank you.
Counsel, thank you. Ms. Wellens?
Yes,
would you
thank
like to
you.
Take a few minutes for rebuttal.
Very briefly, Your Honor. I think that Appelli says it best that 11947 is not a detention statute. It isn't. It doesn't need to be, because we have a detention statute. It is 23-1322. And the court mentions, the inclusion of habeas into 11947, but I do think that maybe it was unclear to the legislature that habeas should not be included in 11947, but it isn't unclear that the detention statute of 23-1322 provides for substantive rights and procedural rights, and it provides a very, very delineated scheme for when people can be detained and when they must be released. May
I ask you a question?
Sure.
If a defendant at the outset is found properly to be, which is to say by clear and convincing evidence, to be a danger to the community that no other alternative conditions of reliefs can adequately protect the community from. Is there any reason to think that after 100 days or whatever, that situation changes and needs to be revisited without the defendant coming forward? In other words, in your view, without the defendant coming forward and in some way saying, look, the situation has now changed. I'm no longer such an unmitigated danger to the community.
I think so.
Why would one think that?
Well, because I think that the burden does shift, right? So I think that 1322 was crafted to.
No, but we're not talking about shifting the burden. We're talking about a factual determination that's been made.
But it's a factual determination within.
It doesn't go away after 100 days.
It doesn't, but neither does the language of 1322.
I mean, the government had the burden on that factual determination.
In the first 100 days, the government had that burden. But the rights of the defendant and the defendant's rights to due process are built into 1322. And it specifically says that after 100 days, no matter what, I mean, we have a code that specifies that there are certain.
It doesn't say no matter what. It says after 100 days, unless a whole lot of reasons are put forward for extending it. And it's very loose.
My reading of 1322 doesn't include a whole lot of readings, a whole lot of reasons. They're specific and delineated. And the government in their response says that, well, we could come in and we could file a 20-day extension after 20-day extension after 20-day extension, and that there are no upper limits in these hundreds of cases that we have. Well, first of all, that tells me that the government is aware that there are hundreds of individuals that are being held past the time frame that they are statutorily supposed to be held. But the government hasn't done that. They're saying that they don't need to do that because
it's silly to do that. It's silly to require that. We have a pandemic. The same reason for every defendant, and it's a reason that doesn't go away after 20 days. It's a reason that sticks around for quite a long period of time. So to say that this is a situation where it would really make a big difference and really is an important requirement to have the government come in every 20 days for every one of the defendants. This is silly, I think.
Well, I don't know if it's silly, but
the fact that this is not a factual situation in which that's a plausible thing to require gets you nowhere except a waste of time.
I think it's silly to require the defendant to keep filing bond review motions when they are being indefinitely held and being punished for the fact that they cannot go to trial. I think that it might be burdensome for the government to continue to have to defend their detention, but I think that at some point they have to under the rules and under the code. Judge Nebaker made a point of, well, can we somehow ameliorate this? Can we somehow have the government come in and say, well, in this case, we might not be able to go to trial, or, we don't have the evidence anymore. The DNA is contaminated, or we lost a witness. And Appellee's response was, well, that's a policy decision. The council or the legislature can deal with that. The council and the legislature can deal with the framing of these codes and these regulations, but they haven't, right? They have a detention statute that is very specific. It provides for specific timeframes. It provides for specific reasons why those timeframes could be extended. And we have an all-encompassing emergency legislation that is not, per the government's own words, a detention statute. So I think that on its face, I think that statute is bad, but even if it's not bad, then we have to have some sort of fail-safe, some sort of valve or something that the defendants who are being held in these, again, lengthy, protracted holds, like Mr. Sharp specifically, something that the government has to do, some sort of protection for them, as Attorney Weidman indicated.
Well, but that's what I was getting at. What is it that the government should be required to do if the facts that originally supported the detention to protect the community have not changed?
I think that some sort of higher standard or higher burden, and it's within the court's power to do that. I understand
one thing you're arguing is that that you should ratchet up the requirement from probable cause to a higher standard of likelihood that the person committed the offense. Although, so that's one thing that's been suggested.
Correct. And I mean, and have those hearings and have that opportunity for the defendant to be heard. At this point, it hasn't happened. There has been no lengthy hearing, and there certainly wasn't a hearing before the last bond review motion was denied. It was denied on the papers within several days of the government filing their opposition. There was nothing There was no right or opportunity to have a full-scale hearing and to consider.
Well, the appropriateness of that depends on what was proffered.
Yeah, I assume so, Your Honor. But I think that, you know, again, some sort of ratcheted up standard. Can I state that specifically what that should be right now? It has to be more. I know that it has to be more than what is a probable cause standard. That's just not sufficient to keep Mr. Sharps detained into the 15th, the 16th, the 17th, the 24th month of his life.
Well, let me thank all counsel for very fine arguments. And the length of time we've devoted to the arguments this morning is an indication of how seriously we take them. The case is now submitted. You may all log off.
Thank you.
This court is now adjourned.